defendant's contest to an added count, larceny less than $200. That one is successful plea to that charge. Counts 1 and 2 would dismiss. Defendant free full restitution on all counts. That supports full understanding of the agreement.
Yes, that is. It's in the.
Is that correct?
That's correct.
Yes. Yes.
Right. You solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do. Thomas Vasher. Vasher, it's this court to understand you're going to plead no contest to the charge of larceny less than $200. That's punishable by up to 93 days in jail, $500 fine plus court costs. The fine could be increased times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that?
Yes, Your Honor.
All right. Do you understand what a no contest plea is?
Yes, Your Honor.
Two things about it I have to make sure that you understand. The first thing is, you know what you're going to have to do. Yeah. First thing about a no contest plea is it means that you're not further desirous or wanting to contest this charge. You're going to have to do something about that. You're going to have to put something over it because it's coming right in at me. I don't care.
Doors or the windows. It's the windows outside,
I don't
right?
care that it can't come in. The second thing you need to understand is that for purposes of sentencing, the court's going to treat you the same as though you had pled guilty. You understand that?
Yes.
All right. You understand, sir, also that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Garwood in the 15th District Court.
Yes.
All right. Still wish to plead no contest?
Yes, Your Honor.
Basis for the no contest plea?
Civil liability.
And sir, to that charge, how do you plead?
No contest.
Now you understand that by pleading no contest, you'll not have a trial of any kind.
Yes, Your Honor.
Signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
Oh, Your Honor.
Look at paragraph 5. You'll see a copy. Those are your rights which are part of a trial. You understand by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole? Has anybody promised you anything other than what's been stated here today to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will.
Yes, Your Honor.
Court has been provided and has reviewed Ann Arbor Police Department report for their case number 25-24098. Any objection to the court having reviewed that report?
No.
None from defense.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Sir, I do have to advise you that if between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined in court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that?
Yes, Your Honor.
Your Honor,
Counsel, you're aware of any other promises, threats, or other inducements which have led to this plea?
No.
none from defense.
And have I complied with the court rule?
People are satisfied.
Yes, Your Honor.
Court will accept the defendant's plea to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation.
Your Honor, would the court consider immediate sentencing? He has 89 days, he has actually 125 days credit. He went to treatment, he came back and has 89 on the current.
Restitution?
Restitution will be 500.
Yes, we're agreeable on 500 restitution.
You should have let me know that you wanted that beforehand. I'm not going to immediately sentence him. Is this the only thing he's held on?
No, he's got a DV case, but the bond is only 10%, I believe. And he tells me his sister was going to pay that if he was going to get out on this case. So
I'll give him a PR. I don't have, if that's the number of days, I don't have a problem with that, but I'm not going to sentence him.
okay, thank you, Judge.
Anything expanded? June 23rd, 2026, 9:08 before Judge Garwood. Bond in this case is to a $5,000 personal recognizance bond. Thank you.
You're gonna get out, you're gonna have to show up.
Just be in custody.
Bobby Rogers.
Court calls case People versus Terry Williams.
Morning, Your Honor. Raymond Cook for the people.
Good morning, Your Honor. On behalf of the Attorney Nicholas North, Your Honor, unfortunately, I have not been able to make contact with Mr. Williams. I haven't seen him here today, not in the hallway, not in the courtroom. For him not being here, I've been texting and calling.
And Your Honor, for the court's consideration, the people are not here. Frankly, I don't think I will be able to proceed at a future date. We've not had contact with the victim.
Well, but he needs to get here, otherwise he's gonna get a warrant for a dismissal.
Your Honor, I can keep calling.
Keep going. Court calls case People versus Anthony Reeves.
Morning, Your Honor. Raymond Cook for the people.
Good morning, Rob Jacob on behalf of Mr. Reeves, who's in lockup. Approach from the podium. Anthony, when you get to the podium, would you state your name for the record?
Anthony Lamar Reeves.
Thank you.
Time of day for a preliminary exam. This matter of defense is ready to proceed.
People are not able to proceed with this.
I ask this matter be dismissed.
People being unable to proceed. This case is dismissed. That's on the defendant's motion without prejudice. Thank you.
Thank you, Your Honor.
Court calls case People versus Philip DiPatricio.
Morning, Peter was working for the people.
Good morning, Judge Lawrence H. Margolis with and on behalf of the defendant, Mr. DiPatricio. Philip, please state your name for the court.
Hi, Philip DiPatricio. Oops.
Your Honor, the people are not able to proceed this morning on preliminary examination. The victim is apparently out of town for the week. That was communicated in advance to defense counsel earlier this morning. We are able to stipulate to alternatives.
We're working on a resolution. I'm going to provide some.
The individual intact.
No,
That I'm aware of, Your Honor.
different case.
How much time? Because I'm going to tell you my next date. No. My next date is not until the 16th or the 23rd.
I defer to the people. We'd like to get something to Ms. Rozmirsky in her office, prosecutor's office, quickly, and if it's agreeable, present something.
Did you say 16th?
16th or the 23rd.
16th. That's fine. Thank you.
Preliminary examination in person. Earned June 16th, 2026, 9 a.m. Bond.
Thanks, Judge.
What? Oops.
I said this one. One. Oh, well, yes.
Courthouse case People versus Enrique Davis.
Your Honor, President Ellis, the people. Roy Gaines, Senior Assistant Public Defender, representing us today, the verdict.
Eric Davis, I'm sorry. I always give one name.
Eric Davis.
Thank you.
Your Honor, unfortunately, one of my witnesses is not able to be here today, so I'm not able to proceed.
We move for dismissal.
People being unable to proceed, this case is dismissed. That is without prejudice on the defendant's motion. All right. Thanks.
Your Honor.
Thanks. Good. I don't have to call your name anymore. Court calls case People versus Terry Williams.
Morning again, Your Honor. Raymond Cook for the people.
Good morning, Your Honor. On behalf of Mr. Williams, Attorney Nicholas North, PA 6482. Mr. Williams, can you please state your full name?
There's Terry Williams.
Judge, we apologize for that. The bus routes changed, so he wasn't able to make it here on time. We do apologize for that.
Your Honor, the people are still.
What? the bus route changed.
It's no longer at Ann Arbor Blake, so I had to find out where they're running the buses at.
Oh, okay. From where you took off from.
Yeah.
Okay, I got you. Go ahead.
People are still unable to proceed.
People being unable to proceed, you're making a motion to dismiss.
Yes, Your Honor, we ask for dismissal.
Case is dismissed on defendant's motion. That's without prejudice.
Thank you, Judge.
Thank you.
Thank you.
So, good morning.
Does it dismiss?
So, it's about to. Court calls the case, People versus Caleb Martin.
Morning, Your Honor, reading for the people.
Thank you, Your Honor. Alex Warren, agreeing on behalf of Mr. Martin.
Caleb Martin.
Your Honor, this time the people are unable to proceed.
And the defense would move to dismiss, Your Honor.
People being unable to case on the defendant's motion.
Thank you so much, Judge.
You're welcome, sir. Take care of yourself.
Thank you, Your Honor.
Take the credit because I take the blame. Oh boy. No, yes, really. you two standing over there? Yeah. Okay.
That's all I gotta say.
Okay, all right, then you're good. What's the word?
Yeah. This is the one. Is you not right?
Okay. Oh, gotcha. Court calls the case, People versus Jennifer Robinson.
Good morning, Your Honor. May it please the Solemn Court, David Burgess on behalf of Robinson, who's approaching. Yeah.
Your name?
Jennifer Robinson.
This is a waiver.
That's correct, Your Honor.
Ma'am, you're waiving your right to have a preliminary examination?
Correct.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it. You understand that by waiving that, you will not have that hearing. You'll proceed to circuit court for further resolution. People also waive their right.
Yes.
Preliminary examination having been waived, defendant is bound over to circuit court on a single count. Mr. Burgess.
You waive formal reading, stand mute as to the charges here.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial in this matter will be set.
July 28th at 1:30 with Judge Cup.
July 28, 2026, 1:30 before Judge Coney. Bond continued. Thank you. You may. Case People versus Danette Claiborne.
Good morning, again, Your Honor. Katie Wisworski for the people.
Good morning, Your Honor. May it please the Solemn Court, David Burgess on behalf of Claiborne is approaching.
Your name?
Annette Claiborne.
Oh, what are we doing?
Your Honor, this court is aware this time and place set for preliminary examination. The victim not having appeared this morning, people are unable to proceed. And Your Honor, at this time, in light of everything that I am now aware of, I move to dismiss.
No objection.
This case is dismissed by the people.
Thank you.
Nolly Cross.
Thank you.
Thank you, ma'am. Oh. Wow. The State of Michigan versus Travis May.
That was the people, Your Honor.
Ed Rodriguez for Travis May.
This one's right here. And your name, sir?
My name's Travis May.
Court has before the plea form that indicates that the defendant is going to be pleading no contest to the charge retail fraud third and added count 2, the 93-day offense. Upon a successful plea to that charge, count 1 would be dismissed. That is the court's full understanding of the agreement.
Yes, Your Honor, that's what we have.
May I have him sworn?
Raise your right hand. Solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
State your name, please.
Travis Duran May.
Sir, it is this court's understanding that you're going to plead no contest to the charge of retail fraud in the third degree. That's a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that?
Yes, sir.
All right. Do you understand what a no contest plea is? I do. Things about it, I have to make sure that you understand it. First of all, it means that you're not further desirous or wanting to contest this charge. You understand that? Yes. Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes.
All right. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Perry in the 15th District Court. Understand? All right. Basis for the no contest plea?
Civil liability, Your Honor.
Sir, to the charge of retail fraud third, how do you plead?
No contest.
No contest, I'm sorry.
You understand that by pleading no contest, you'll not have a trial of any kind?
Yes.
You signed an advice of rights form, is that correct?
Correct.
Any questions regarding those rights?
No.
Look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading no contest, you're giving up those rights as well as all the rights in that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
And of your own free will?
Yes.
Court has been provided and has reviewed University of Michigan Department of University of Michigan Police Department for their case number 26-27978. Any objection to the court having reviewed that report?
Not from the people.
No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of the offense. Sir, I do have to advise you, in the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that?
Yes, I do.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
And have I complied with the court?
People are satisfied.
Defense is satisfied.
Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing will be June 16th. June 16th, 2026, 8:30 before Judge Perry.
Thank you, Your Honor. May I address bond?
Sure.
Dealing with the reduction of the charge to a misdemeanor. Mr. May had a previous order to go to community corrections. He did not take advantage of that. And what he's asking for today is to be re-referred to community corrections so he can attend. He understands the consequences of him not going, and him talked about things that he needs to address prior to a sentencing date. Can be contacting through the individual he contacts through CMH. He's going to attend community corrections. He's going to he's working on getting into Sacred Heart.
Yes.
And he's also working, he has my phone number to be able to contact with me, and he's got to contact probation. So he knows that if he doesn't roll those things, that's going to have a different outcome for purposes of sentencing. He is looking for a probationary term.
Yes.
And so that's what we're asking for today.
Any response from the people?
We'll leave it for the court's discretion, but we put request that you would be interviewed by probation.
Which was, I believe, a PR with conditions will be reinstated once he completes probation and
Thank you.
Thank you.
Thank you.
Thank you.
This courtroom hearing highlights several important aspects of how judges manage multiple cases in a fast-paced court session. Throughout the proceedings, the court focuses on maintaining order, reviewing bond conditions, and ensuring that each defendant understands the legal process moving forward. One of the most notable moments comes when the judge decides that a $5,000 bond will remain continued, signaling that the court believes the existing bond conditions are still appropriate based on the circumstances presented during the hearing. The hearing demonstrates how judges balance public safety, procedural fairness, and the rights of the individuals appearing before the court. In cases involving bond reviews, the court often considers factors such as prior criminal history, compliance with earlier court orders, risk of failing to appear, and the seriousness of the allegations. By continuing the $5,000 bond, the judge indicates that no major change in circumstances was presented that would justify lowering or removing the bond requirement at this stage. Another key takeaway from the video is the professional but firm tone maintained throughout the courtroom. The judge carefully manages multiple hearings, ensuring that attorneys, defendants, and court staff remain focused and efficient. These proceedings also reveal how quickly courts must process numerous legal matters while still giving each case individual attention. The video further reflects the importance of preparation and respectful communication in court. Defendants who appear organized and cooperative generally help proceedings move more smoothly, while attorneys are expected to provide clear arguments supported by facts and procedural law. Even brief hearings can carry significant consequences, particularly when decisions about bond conditions, future court dates, or custody status are involved. Overall, this courtroom session offers viewers a realistic look at how routine criminal hearings are conducted. The continuation of the $5,000 bond serves as a reminder that bond decisions are often based on ongoing evaluation rather than emotional arguments alone. The judge's rulings throughout the hearing emphasize consistency, courtroom discipline, and adherence to legal procedure, while multiple cases move through the system in an orderly manner.